Hello friends, welcome back to the series How to Become an Expert in the Constitution of India. This is video number 2. I hope you've enjoyed video number 1 and benefited out of it. Just to recap, this is a new series of How to Become an Expert in the Constitution of India in just 20 minutes a day, presented by me, Advocate Siddharth Arora. I'm a practicing advocate in the Supreme Court of India, field of specialization being criminal law and constitutional law. I've authored the book History of the Constitution of India. I am an honorary faculty at various law and IAS training institutes. Well, this series would be of great benefit to lawyers and law students, UPSC, IAS aspirants, as well as general public who desire to know about the Constitution of India. Just to recap, I have subdivided this series into video snippets of 20 minutes or less. And I assure you that if you go through this series, you will be amongst the top 10% as far as the knowledge of the Constitution of India is concerned. That's a promise. Let's see if we are able to successfully execute this promise. Right. Let's go to the topic without further ado. If you find the series useful, I request you to please like, subscribe and share the video. This is my vested interest in imparting the useful knowledge that I'm imparting to you via this series. Alright, let's go for it. We are today discussing what is popularly called as Office of Profit. Much talked about in the news channels, thanks to the gentleman in the picture. And this is the case file. We are talking of the disqualification of the 21 MLAs of Aam Aadmi Party on the grounds of occupying Office of Profit. This controversy is not only a political controversy, it is also a constitutional question, which through this video I'll first clarify. Before you start commenting on what is good or what is bad, you should know what the Constitution and the law says about Office of Profit. Let's go for it. This is a complicated topic. I'll simplify it for you. First of all, what is the concept of Office of Profit? The concept of Office of Profit is provided under Article 102, 1A and Article 191, 1A of the Constitution of India. Let's look at Article 102. It says, a person shall be disqualified from being a member of either House of the Parliament. What I have marked in yellow, can you remember that? The either House of the Parliament, if he holds any Office of Profit under the Government of India or Government of any state. The crucial part is here, the one in orange. It says, other than an office declared by Parliament by law not to disqualify its holder. Let me clarify this in just a moment. 191A, Article 191, 1A says, a person shall be disqualified for being a member of the Legislative Assembly or Legislative Council of a state. Again, same. If he holds any Office of Profit under Government of India or the Government of any state, again the crucial part in orange, other than an office declared by the legislature of the state by law not to disqualify its holder. So in short, if I look at Article 102 and Article 191, what does it say? That you cannot occupy an Office of Profit. Also it says that the Parliament or the legislature of the state, as the case may be, has the power to declare by law that a XYZ office is an Office of Profit or not. So they can declare an X office to be an Office of Profit and a Y one to not to be. So this is a discretion which has been given to the Parliament as well as to the legislature. This orange highlight is going to play a crucial role in understanding Office of Profit and the controversy that we are discussing in this video. Please remember this. Let's go. Now, where did this thing called Office of Profit originate from in the first place? Well, it originated from what is called as ethics. Now, the English Settlement Act of 1701 provided that no person who has an office or place of profit under the king or receives a pension from the crown, again, that means royalty, shall be capable of serving as a member of the House of Commons. House of Commons, for all practical knowledge, if you know, is the Lok Sabha of England, so-called. So, I'm repeating, any person who is occupying an Office of Profit or a place of profit under the king or receives any money from the crown will not be allowed to serve as a parliamentarian as a member of House of Commons. Why? The reason to this is so that the king does not have an undue influence on the parliament. So a parliamentarian is not dependent on the king for money, and therefore he will perform his duties without any bias. Ethics, my friends, ethics. This is the basis of office of profit. So, is becoming a minister to an office of profit? Please remember, every minister is actually a member of the parliament. So, if you are making somebody a minister, are you giving him an office of profit? No. Why not? Not because what you think, not because what I think. It is because Article 102 says that a minister either for the union or for such state is not deemed to be an office of profit. So please remember, the constitution itself says that a minister is not deemed to be an office of profit. Remember this part. So, where does this bring us to this new office, or the so-called talked about office of parliamentary secretaries? Are they deemed to be the office of profit? Deemed as in, are they understood to be an office of profit? Yes. For Delhi, yes. Now, in 1997, Delhi Assembly had passed a law which provided 2 exemptions to the office of profit and a 3rd exemption in 2006 by an amendment. Please remember the part that was highlighted in orange. The legislative assemblies or the parliament can by law decide whether an XYZ office will be an office of profit or not. In 1997, very crucial for you to remember, Delhi Assembly passed a law which provided 2 exceptions to the office of profit and a 3rd one in 2006. They missed something. The office of parliamentary secretary was not one amongst these 3 exceptions. Hence, parliamentary secretary's office for Delhi on the day that we are discussing this is deemed to be an office of profit. Ye Delhi hai meri jaan. Delhi has a unique situation. It is an NCT, National Capital Territory of Delhi, and not a full state. So, there are certain limitations to Delhi vis-a-vis a full state. What is this? A bill passed by the Delhi Legislative Assembly will not become a law unless approved by the Lieutenant Governor and the Centre. This is something which our Chief Minister, Mr. Arvind Kejriwal, is hugely aggrieved by. But you cannot take any step until unless it's provided in the Constitution. The Constitution itself says that a bill passed by the Delhi Legislative Assembly shall not become a law unless approved by the Lieutenant Governor of Delhi and the Centre. I hope you remember and memorize this line, because this is going to be the crux of the problem in just 5 minutes more. So, let's understand the order of events. In March 2015, the Aam Aadmi Party Chief Minister Arvind Kejriwal appoints 21 Aam Aadmi Party legislators as parliamentary secretaries. Oblivious to the fact, very oblivious to the fact, ignoring the fact that parliamentary secretaries is an office of profit. It did not strike him probably, or maybe he chose to ignore. That is his problem. We are not here to comment upon that. The point here is, in March 2015, 21 Aam Aadmi Party legislators have now been appointed by Mr. Arvind Kejriwal as parliamentary secretary. The order said that they will not get any money, any perks, but they will have some space to live in the parliamentary's office to work and could use government transport for official purpose. Now, that brings us to another very crucial word. Is office of profit only for money? No. Office of profit is profit. Profit means advantage of any kinds, be that of even that of a vehicle or that of an office. Let's go for it. Now, a storm starts brewing. A public interest litigation is filed by an NGO called as Rashtriya Mukti Morcha against this appointment. Then, a fellow advocate, Mr. Prashant Patel, petitions the President against this appointment, who in turn forwards this petition to the Election Commission of India. In March 2016, Election Commission of India takes cognizance of this appointment and issues notice to all the 21 legislators to show cause as to why they should not be disqualified on the grounds of occupying office or profit. Trouble, my friends. Huge trouble. Now, Kejriwal, wise man, he takes steps immediately in damage control. So what does he do? He passes a bill amending the Delhi Members of Legislative Assembly within bracket Removal of Disqualification Act 1997. Remember, there were 3 exemptions. Parliamentary Secretary was not one of the exemptions. I hope you recall from the previous slides. And also remember that the Legislative Assembly is much within the powers to bring XYZ office into an office of profit or to remove it. So he does this. What does he do? He decides that let's pass a law, let's make an amendment, and we will remove the word office of profit from the definition for parliamentary secretary. Work done? No. Sorry, it's too late. Why? Because Delhi is a special case and the president at that time, Mr. Pranab Mukherjee, in June 2016 rejects the bill. Why? Please remember the earlier line. In Delhi, a bill must be approved by the Lieutenant Governor and the Centre to become a law. So, although Mr. Arvind Kejriwal attempts damage control, it doesn't happen. And this is huge problem now. Ouch. Let's see. Another blow comes. Delhi High Court scraps this appointment of the 21 legislators as parliamentary secretaries. So now this office no longer exists and we thought the story is over. But no. Remember, Election Commission of India had already served a notice to the 21 Aam Aadmi Party legislators. So now they started discussing, they started calling for statements, they started utilizing judicial mind on whether or not to disqualify the Aam Aadmi Party legislators. No. The moment this happens, Aam Aadmi Party people oppose it. The legislators claim that why is the Election Commission of India trying to hear this earlier pending petition as the High Court has already scrapped the office. The office no longer exists. So what is the problem now? Election Commission of India says no. From March 13, 2015 to September 8, 2016 till the time Mr. Pranab Mukherjee had scrapped the bill, you were holding an office of profit. Who's going to answer for that? So, on one side, Aam Aadmi Party says, game over, let's forget about it, it's all in the past. Election Commission of India says, not yet. So, what is now the situation? Situation here is that Election Commission of India has recommended the President to disqualify these 21 legislators on the grounds that they were occupying office of profit. The President has accepted these and disqualified the legislators. Before we go any further, please remember that the recommendations of the Election Commission of India are binding on the President. Hence, this is no surprise that the President has accepted these recommendations and disqualified the legislators. Aam Aadmi Party, as was expected, has challenged the order before the Delhi High Court. On the date that we are discussing this is 25th January 2018. The matter is sub judice. The Delhi High Court is still to decide whether or not this disqualification is valid in the eyes of the Constitution or not. So, picture abhi baki. Enough, I hope, on the grounds or the topic of office of profit. If you have any doubt, feel free to mail on siddhartharoraofficial@gmail.com. Trust me, my friends, what I've just taught you is something that most people don't realize or they don't understand. If you know this much, you're on the way to become a champ. Until next time, take care. Please don't forget to like and subscribe to this channel. We'll continue with this in video number 3. Until then, all the best.